It's early in the morning of June 3, 1961, in Panama City, Florida. A pool room has been burglarized. Someone has stolen beer, wine, and money. A witness claims he saw Clarence Earl Gideon in the pool room with a bottle of wine and some money in his pockets at 5:30 a.m. Gideon is arrested. The charge is breaking and entering with the intent to commit petty larceny, which is a felony under Florida law. But that's not the end of the story.
Hi, I'm Doug Ginsburg, and I'm a federal judge. The case of Gideon versus Wainwright is a landmark decision that protects the rights of a poor person accused of a crime. When Clarence Earl Gideon was charged with felony breaking and entering, he couldn't afford an attorney, so he requested one be appointed for him by the court. But Florida law, unlike federal law, allowed its courts to appoint counsel for indigent defendants only in death penalty cases. And of course, the punishment for breaking and entering was not death, so the court denied his request. Gideon had no alternative but to defend himself. He was convicted and sentenced to 5 years in prison. But while in prison, he became a jailhouse lawyer. He studied the Constitution, and he wrote his own appeal. He sued Louis Wainwright, the director of the Florida Department of Corrections, claiming that his Sixth Amendment right to counsel had been violated. In the Bill of Rights, the Sixth Amendment to the U.S. Constitution reads, "In all criminal prosecutions, the accused shall enjoy the right to have the assistance of counsel for his defense." The Florida Supreme Court dismissed his petition, but the United States Supreme Court agreed to hear his case and appointed counsel to represent him. The key issue was, does the Sixth Amendment's right to counsel in felony criminal cases extend to state courts through the 14th Amendment? The 14th Amendment states that no state shall deny to any person within its jurisdiction the equal protection of the laws. After oral argument and deliberations, the decision was unanimous, 9-0 in favor of Gideon. Justice Hugo Black authored the opinion of the court, in which 5 other justices joined, while 3 justices concurred in the judgment with slightly different reasoning. States were now required to provide attorneys to all defendants charged with a felony who cannot afford their own lawyers, no matter the crime. Justice Black reasoned that the right to counsel was fundamental and essential to fair trials, and therefore a basic right of every defendant. Gideon versus Wainwright clearly extended equal justice to all, rich and poor, and itself was extended to apply later to any case, even a misdemeanor, in which somebody was at risk of going to jail. Clarence Earl Gideon was retried by the state of Florida, this time with a court-appointed lawyer. The jury took only 1 hour to find that he was not guilty as charged.
Gideon versus Wainwright was decided in favor of Gideon by a 9-0 unanimous vote in 1963. The key principle was the Sixth Amendment's right to an attorney. In this case, the Sixth Amendment's right to an attorney extends due process protections to felony defendants in state courts.